process is governed by statute. So if you want to impose those changes, we go see our representatives and senators and see if they're prepared to introduce legislation that that will affect and change or establish protocols for writing wills. As the law currently stands, it hasn't been changed except to really liberalize the ability to make the will.
Can I respond?
In fact, there's most recent change allows for the witness to be in the conscious presence of the testimony.
Final comment too. First of all, he mentioned the attestation of wills, the change so you could be in the conscious presence. I testified against that bill. I invite you to look up the testimony through the House Judiciary Committee. After I testified, a world-renowned expert in the area, Dr. Bennett Bloom from Arizona, responded to me, and he's a close acquaintance, that bill could not be for the purpose stated by its sponsor, which is what I testified to on different grounds. Dr. Bloom's did it on medical grounds, and there's another piece of fraud propagated by the Bar Association, and that's why there's no legislation, because the Bar Association and the judiciary block every effort, lobby very hard against every effort, and bring back forth bad legislation, including House Bill, I think it was House Bill 318 in our conversation, which you mailed, your secretary mailed to me, which had nothing to do with what we were talking about, but yet led Carol Dayton to say she couldn't tell which was a better legal approach. What is going on here is, he made a comment about the presumption of all of us here about being competent and whatnot. We're not talking about you being competent here. We're talking about somebody under morphine or suffering from Alzheimer's. And there are situations where the presumptions are that you're not competent and then have to be cited to either uphold or avoid that. And I've asked that people like Judge Swift be responsible for identifying the situations where that presumption is the document's not valid, so you know where to put the protections. And I made that recommendation first to the Acting Assistant Secretary of the Administration on Aging before this commission was started, just shortly before this commission was started, and then I gave it to Ursel to be included, to be addressed by this commission. In other words, a good place to start is to ask the authorities, where is the presumption changed? I know for a fact that that presumption was changed in my own case. The presumption was my father was not competent. But the presumption itself doesn't mean much if you can still ignore the evidence. And if you still don't have the evidence because it wasn't collected in the timely manner needed by the people who need to collect it in the objective manner by the protocol that makes sure it's done right. That's my closing statement.